Okay, this section of police interrogation and confessions, talking about applying Miranda, is got a section title, 5. If a suspect invokes his right to counsel and there is a break in Miranda custody, at what point, if at all, can the police try to interrogate the suspect again? If a suspect is serving a prison sentence for an unrelated crime at the time the police try to question him, does his release back into the general prison population constitute a break in custody? Maryland v. Shatzer, 2010. Justice Scalia delivered the opinion of the court in August of 2003 when defendant Shatzer was serving a sentence in the state correctional facility for an unrelated crime. A detective tried to question him about allegations that he sexually assaulted his own son. However, when Shatzer invoked his right to counsel, the detective ended the meeting and Shatzer was then released back into the general prison population. 2.5 years later, on March 2nd of 2006, another detective obtained more information about the incident and decided to discuss the matter once more. Shatzer was still serving time in a correctional facility. And his meeting with the detectives took place in a small room apart from the general prison population. At this meeting, Shatzer signed a written waiver of his Miranda rights. After 30 minutes of questioning, during which time Shatzer made an incriminating statement, he agreed to take a polygraph examination. 5 days later, again, after being advised of his rights and after again waiving his rights in writing, Shatzer took the polygraph examination. He was informed that he had failed the exam. Then he made another incriminating statement. The trial court concluded that the Edwards protections did not apply because Shatzer had experienced a break in custody for Miranda purposes between the 2003 and 2006 interrogations. However, the Maryland Court of Appeals reversed, holding that the passing of time alone is not enough. Is insufficient to end the Edwards protections, and that, even if a break in custody exception did exist, Shatzer's release into the general prison population did not constitute such an exception. We consider whether a break in the custody ends the presumption of involuntariness established in Edwards versus Arizona. And the Edwards court determined that the traditional standard for waiver was not sufficient to protect a suspect's right to have counsel present at a subsequent interrogation if he had previously requested counsel. Additional safeguards were necessary. The court therefore superimposed a second layer of prophylaxis describing Edwards. The rationale of Edwards is that once a suspect indicates that he is not capable of undergoing custodial questioning about advice of counsel, any subsequent waiver that has come at the authorities' behest and not at the suspect's own instigation is itself the product of the inherently compelling pressures and not the purely voluntary choice of the suspect. Under this rule, the voluntary Miranda waiver is sufficiently at the time of an initial attempted interrogation to protect a suspect's right to have counsel present, but it is not sufficient at the time of subsequent attempts if the suspect initially requested the presence of counsel. The implicit assumption, of course, is that the subsequent requests for interrogation pose a significantly greater greater risk of coercion. That increased risk results not only from the police's persistence in trying to get the suspect to talk, but also from the continued pressure that begins when the individual is taken into custody as a suspect and sought to be interrogated. Pressure likely to increase as custody as the suspect and sought to be interrogated. Pressure likely to increase as presumption of involuntariness ensures that police will not take advantage of the mounting coercive pressures of prolonged police custody, but repeatedly attempting to question a suspect who previously requested counsel until the suspect is badgered into submission. We have frequently emphasized that the Edwards rule is not a constitutional mandate, but judicially prescribed prophylaxis, because Edwards is our rule, not a constitutional command. It is our obligation to justify its expansion. Arizona v. Robertson, 1988, Kennedy dissenting. Lower courts have uniformly held that a break in custody ends the Edwards presumption, but we have previously addressed the issue only in dicta. A judicially crafted rule is justified by the reference to its prophylactic purpose and applies only where its benefits outweigh its costs. Edwards. Fundamental purpose is to preserve the integrity of an accused's choice to communicate with police only through counsel by preventing police from badgering a defendant into waiving his previously asserted Miranda rights. Thus, the benefits of the rule are measured by the number of coerced confessions it suppresses that otherwise would have been admitted. It is easy to believe that the suspect may be coerced or badgered into abandoning its earlier refusal to be questioned without counsel in the paradigm Edwards case. That is a case in which the suspect has been arrested for a particular crime and is held to uninterrupted pretrial custody while that crime is being actively investigated. After the initial interrogation, up to and including the second one, he remains cut off from his normal life and companions, thrust into and isolated in an unfamiliar, police-dominated atmosphere. Miranda, where his captors appear to control his fate. That was the situation confronted by the suspects in Edwards, Robertson, and Minnick, the three cases in which we have held the Edwards rule applicable. When, unlike what happened in these three cases, a suspect has been released from his pretrial custody and has returned to his normal life for some time before he later attempted interrogation, there is little reason to think that his change of heart regarding interrogation without counsel has been coerced. He has no longer been isolated. He has likely been able to seek advice from an attorney, family members, and friends, and he knows from his earlier experience that he need only demand counsel to bring the interrogation to a halt. So Minnick is in the footnotes. Actual reinterrogation consultation with an attorney during continued custody did not suffice to avoid the application of Edwards. That does not mean the ability to consult freely with attorneys and need only demand counsel to bring the interrogation to halt. Okay, whatever. That's the majority opinion. Trying to get attitude. Okay, the footnote. Forget the footnote. Minnick. No, Minnick's about. Minnick applied that what? Actual pre-reinterrogation consultation with attorney during continued custody did not suffice to avoid application of Edwards. Okay. Investigative custody does not last indefinitely. In these circumstances, it is far-fetched to think that the police officers asking the suspect whether he would like to waive his Miranda rights will any more wear down the accused than it did the first such request at the original attempted interrogation, which is, of course, not deemed coercive. His change of heart is less likely attributable to badgering than it is to the fact that further deliberation in familiar surroundings that cause him to believe, rightly or wrongly, that cooperating with the investigation is in his interest. Uncritical extension of Edwards to the situation would not significantly increase the number of genuinely coerced confessions excluded. The justification for a conclusive presumption disappears when application of the presumption will not reach the correct result most of the time. At the same time that extending the Edwards rule yields diminished benefits, extending the rule also increases its costs. And in fact, voluntary confessions it excludes from trial. And the voluntary confessions it deters law enforcement officers from even trying to obtain. Voluntary confessions are not merely a proper element of law enforcement, they are an unmitigated good. The only logical endpoint of Edward's disability and termination of Miranda custody and any of its lingering effects without that limitation and barring some purely arbitrary time limit, every Edwards prohibition of custodial interrogation of a particular suspect would be eternal. LOL. I like this quote. The prohibition applies, of course, when the subsequent interrogation pertains to a different crime, when it is conducted by a different law enforcement authority, and even when the suspect has met with an attorney after the first interrogation, and it not only prevents questioning ex ante, it would render valid ex post confessions invited and obtained from suspects who, unbeknownst to the interrogators, have acquired Edwards immunity previously in connection with any offense in any jurisdiction in a country that harbors a large number of repeat offenders. This consequence is disastrous. We conclude that such an extension of Edwards is not justified. We have opened its protective umbrella far enough. The protections offered by Miranda, which have been deemed sufficient to ensure the police respect the suspect's desire to have an attorney present for the first time, the police interrogate him, adequately ensure that result when a suspect who initially requested counsel is reinterrogated after a break in the custody that is of sufficient duration to dissipate the coercive effects. If Shatzer's return to the general prison population qualified as a break in custody, a question we address infra meet that durational requirement. But what about, I think they were saying it was an arbitrary durational requirement. Arbitrary. I don't know. What had it been a year, a week? It is practical to leave the answer to that question for clarification in future case-by-case adjudication. Law enforcement officers need to know with certainty and beforehand when renewed interrogation is lawful. And while it is certainly unusual for this court to set precise time limits governing police action, it is not unheard of. In County of Riverside versus McLaughlin, we specified 48 hours as the time with which police must comply with the requirement of Gerstein versus Pugh. So they want a bright line, right? And I think that point about the fact that different police officers could be interrogating them. Interrogation by different officers is a risk that I should note here. So, police must comply with the requirement of Gerstein versus Pugh. Don't know what that is. That a person arrested without a warrant be brought before a magistrate to establish probable cause for continued detention. Like McLaughlin, this is a case in which the requisite police action there presented to a magistrate here. Abstention from further interrogation has not been prescribed by statute, but has been established by opinion of this court. We think it appropriate to specify a period of time to avoid the consequence that continuation of the Edwards presumption will not reach the correct result most of the time. It seems to us that periods That period is 14 days. That provides plenty of time for the suspect to get reacclimated to his normal life, to consult with friends and counsel, and to shake off any residual coercive effects of his prior custody. That's kind of a long time. What if he paid bail? Like, oh, that's what I'm thinking, but never mind. Then it's not a very long time. Anywho, the 14-day limitation meets Shatzer's concern that a break-in custody rule lends itself to police abuse. He envisions that once the suspect invokes his Miranda right to counsel, the police will release the suspect briefly to end the Edwards presumption and then promptly bring him back into custody for re-interrogation. But once the suspect has been out of custody long enough, 14 days, to eliminate its coercive effect, there will be nothing to gain by such gamesmanship, nothing that is except the entirely appropriate gain of being able to re-interrogate a suspect who has made a valid waiver of his Miranda rights. Shatzer argues that ending the Edwards protections at a break-in custody will undermine Edwards' purpose to conserve judicial resources. To be sure, we have said that the merit of the Edwards decision lies in the clarity of its command and the certainty of its application, from Minnick. But clarity and certainty are not goals in themselves. They are valuable only when they reasonably further the achievement of some substantive end. Here, the exclusion of compelled confessions. Confessions obtained after a 2-week break in custody and a waiver of Miranda rights are most likely to be compelled and hence are unreasonably excluded. In any case, a break-in custody exception will dim only marginally, if at all, the bright-line nature of Edwards. After the 2003 interview, Shatzer was released back into the general prison population where he was serving an unrelated sentence. The issue is whether that constitutes a break in Miranda custody. Here we are addressing the interim period during which a suspect was not interrogated, but was subject to a baseline set of restraints imposed pursuant to a prior conviction. Without minimizing the harsh realities of incarceration, we think lawful imprisonment imposed upon conviction of a crime does not create the coercive pressures identified in Miranda. Interrogated suspects who have previously been convicted of crime live in prison. When they are released back into the general prison population, they return to their accustomed surroundings and daily routine. They regain the degree of control they had in their lives prior to the interrogation. Sentenced prisoners, in contrast to the Miranda paradigm, are not isolated with their accusers. They live among other inmates, guards, and workers, and often can receive visitors and communicate with people on the outside by mail or telephone. Their detention, moreover, is relatively disconnected from their prior unwillingness to cooperate in an investigation. The former interrogator has no power to increase the duration of incarceration, which was determined at sentencing. And even where the possibility of parole exists, the former interrogator has no apparent power to decrease the time served. This is in stark contrast to the circumstances faced by the defendants in Edwards, Robertson, and Minnick, whose continued detention as suspects was arrested with those controlling their interrogation, and who confronted the uncertainties of what final charges they would face, whether they would be convicted, and what sentence they would receive. A few words in response to Justice Stevens' concurrence. It claims we ignore that when police tell an indigent suspect that he has the right to an attorney and then interrogate him without providing a lawyer, the suspect is likely to feel that the police lied to him and that he really does not have any right to a lawyer. The fallacy here is that we are not talking about re-interrogating the suspect. We're talking about asking his permission to be interrogated. An officer has in no sense lied to a suspect when, after advising as Miranda requires, he promptly ends the attempted interrogation because the suspect declines to speak without counsel present, and then 2 weeks later re-approaches the suspect and asks, "Are you now willing to speak without a lawyer present?" Contrary to the concurrence conclusion, there is no reason to believe a suspect will view confession as the only way to end his interrogation, when before the interrogation begins, he is told that he can avoid it simply requesting that he not be interrogated without counsel present, an option that worked before. The concurrence also accuses the court of ignoring that when a suspect asks for counsel until his request is answered, there are still the same inherently compelling pressures of custodial interrogation on which the Miranda line of cases is based. We do not ignore these pressures, nor do we suggest that they disappear when custody is recommended after a break. But if those pressures are merely the same as before, then Miranda provides sufficient protection as it did before. The Edwards' presumption of involuntariness is justified only in circumstances where the coercive pressures have increased so much that suspect waivers of Miranda's when custody is unbroken. And that okay. I think this is the last 2 paragraphs. Let's hope. Yeah. In the last analysis, it turns out that the concurrence accepts our principal points. It agrees that Edwards' prophylaxis is not perpetual. It agrees that a break in custody reduces the inherently compelling pressure upon which Edmonds is based. It agrees that Shatzer is released back into the general prison population constituted a break in custody, and it agrees that in this case the break was long enough to render Edwards inapplicable. We differ in 2 respects. Instead of terminating Edwards' protection when the custodial pressure that were the basis for that protection dissipate, the concurrence would terminate it when the suspect would no longer feel that he has been denied the counsel he has clearly requested. This is entirely unrelated to the rationale of Edwards. If confidence in the police's promise to provide counsel were the touchstone, Edmonds would not have applied in Mimic, where the suspect in continuing custody actually met with appointed counsel. The concurrence's rule is also entirely unrelated to the existence of a break in custody. While that may relieve the accumulated coercive pressures of custody that are the foundation for Edwards, it is hard to see how it bolsters the suspect's confidence that if he asks for counsel, he will not get one. And secondly, the concurrence differs from us in declining to say how long after a break in custody the termination of Edwards' protection occurs. 2.5 years, it says clearly enough, but it gives law enforcement authorities no further guidance. The concurrence criticizes our use of 14 days as arbitrary and unexplained, but in fact that rests upon the same basis as the concurrence's own approval of a 2.5-year break in custody. How much time will justify treating the second interrogation as no more coercive than the first? Failure to say where the line falls short of 2.5 years and leaving that for future case-by-case determination is certainly less helpful, but not at all less arbitrary. Because Shatzer experienced a break in Miranda custody lasting more than 2 weeks between the first and second attempts at interrogation, Edwards does not mandate suppression of his March 2006 statements, thus as concurring in part and concurring in the judgment. This is Thomas. I just didn't write Thomas. This is going to go on for Page. Justice Stevens concurs. Seems to me that everyone concurs. I'm kidding. There's a dissenting opinion somewhere. But I'm not going through 6 pages to find it.